Hi, everyone. I'm Judge Desire for Knowledge, and on this Legal Matters show today, we're doing wills, the basic steps for the layperson, session one. I will be doing a session two because it contains a lot when we're talking about wills, trusts, and estates. So I'm going to start with wills, and this is the end of the month coming up. Yay, spring is here. And so monthly, I do my Legal Matters show once a month and every week, Know Your Truth Real Talk, live or taped. Normally, my Legal Matters shows are taped because it's lengthy and I don't have time to answer your questions, and I rather have a dialogue with you when it's something that I need to hear. Um, it's not that I don't want to hear your opinions, but I want to get through the legal process of explaining stuff to you without any interferences. And I love you guys enough to have respect. So instead of doing legal matters all the time, um, I do it monthly and I try to tape as much as possible instead of going live on legal matters. And that's why. So thank you for joining this channel, Just Desire for Knowledge. Please like and share and subscribe. There are people out there that may need the information, so I'm willing to give it. I am not an attorney or a judge. I work in the field, and I'm just here to assist the public, the collective, the audience, or whatever you deem yourself proper to be, with information that is vital. In some instances, when it's on legal matters, yes. Maybe things that you didn't know that you can add with the stuff you do know. So as we start with this wills and the basic steps on session two, I will let you know at the end of this tape what I will include that I didn't this time, because it, like I said, legal can be lengthy. So I just want to go through it in a basic terms. It's called legalese, where there where the layperson could understand, and there's no legalese involved in it, which can be very um, hectic for some people to understand. So I'm trying to bring it down to basic forms. Anyway, let's start. So I'm glad you're here with me today. I'm so sorry I can't go live today. I'm probably not next week either. We'll see, but it will be Know Your Truth Real Talk next week. I hope I can go live for you. I'm not sure yet, based on my schedule. So today I'm not live. I'm going to miss you guys, but this is for you guys. So on legal matters, wills, the basic steps for the layperson, session one has begun. With me, Judge Desire for Knowledge. All right. Okay, so it's great that we all create a living trust for your spouse, with your spouse, children, and family considered in it, so that everything is in order when the time comes. It doesn't matter how old you are or whether you have children, single or married. It's important to remember, when creating a living will, those who are entitled to your assets as well as those who are not. Be clear and concise, and you don't have to put who's not entitled. It's rude, so you just leave them out. I will describe the necessary steps if this is not implemented in your implemented in your living trust. Sorry, guys, I am human. This is not AI. This is me. In your living trust, or if you don't have one at the time of your departure, how you can start the process of doing so, you know. And I'm going to try my best to give you the information that I know based on experience and based on facts, okay? So the different types of wills: there's a will, there's a living will, there's a living trust, and dying without a will, called intestate. All right, so I'm going to start with will. A will is a last testament, a legal document that would it's how you would like your assets distributed, you know, things like that. After you die, you can add others to it as just like family, guardians. Some people put charities, dependents, and even pets. So it's up to you. It's your will. I worked in surrogate court a few years ago, because I like to transfer to different areas of the court based on promotions or just knowing those laws and those filing procedures. So I worked in surrogates at one time, and I've seen a case. I won't mention the big star, big girl, very rich billionaire who passed, and she left her pet everything. I mean, when they brought it to the courtroom, the cases, and I know this isn't part of it, but I like to elaborate with cases as well. Her case file, oh, I said her, okay. Her case file was like 20 boxes or more of the will and all her assets and everything that she left for. I don't even think she left for her children or anything. I think everything went to the dog. He had a silver spoon. He ate by a chef was assigned to him. Well, at the end, because it's a lot of stuff that was in that file, at the end of this court case, this lady had not only left the pet a chef and everything, but she died and said that she want, when the laws change, now this is future laws, change, that that pet is supposed to be buried with her. Until then, that pet is to be treated like a king or queen, whichever sex that pet was. But I'm gonna leave it there because I don't want to violate any family's information here, which is private to them. So that was just one portion of what people do in their wills. A testator in a will is the person who creates the will. So that would be the person, you, when you pass, before you pass, the you are the person who creates the will. You are the testator. Tester. All right? Testator. Testator. And the executor is the person a testator appoints to carry out their will. So you'll have an executor that you'll assign. All right. And then you have beneficiaries. Those are the people or organizations who you leave bequests to. And to break that down, a bequest is a gift, cash, and other assets in the will left by the testator. So, or I can say the deceased in case, but I just wanted you to be familiarized with that word, testator. All right. And then in a will is a probate. Um, a probate is like a process, a judicial process where a will is proved in court of law and accepted as a valid public document that is the last true testament of the deceased, where the court authorized the executor, the person assigned, to distribute the assets according to the will as long as there are no disputes or problems. Okay? So, and believe me, I've seen probate with a lot of issues and problems, but that's why they're there. All right. And so in a will, we have that is if you have a will. All right. Now, if you don't have a will, it's called intestate, which is dying without a will. Then courts will assign an administrator to manage the estate and distribute assets. Now, I know in New York City, as I always dealt with the public administrator there, what a sweet job he has, and distribute assets. They distribute that and will send a public notice via a news article in the newspaper to locate the next of kin. I mean, it's not every day people read newspapers, but those public notices are for reasons to take action. And most of them you'll see that there's a cease to have blah, 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 assets, this and that. Everybody's going to want to come, but you got to prove yourself that it's you. So these are the public notice put out in various newspapers, depending on that court. And I'm only speaking for New York State, depending on that court and where they put their notices in, or where that public administrator puts his notices in, because they may do two or maybe just one newspaper. So that's very interesting to always look back at the public notice. You never know if your name is there, you were called in a will, or they're looking for specific families to distribute monies that belong to you, that has been held by the city, wherever that city is. I'm talking about New York City, by that public administrator trying to reach out. So according to the laws of your state, they'll distribute your property and assets to your spouse, your children, your parents, your siblings, all bloodlines, or other relatives, part of your assets, okay? But not in the order of the amounts you would like. So, and they also get a cut for the work they've done, the research, the investigation, and blah, blah, blah. So that's very interesting to know that a lot of people don't know about I didn't even know until I started working in the surrogate court part at one time in my life, and there was a public administrator. I know there's an executor, but this is when you don't have a will. This is when it's intestate, meaning you die, you forgot to do your will, they can't find the will. Hopefully they find it, but if not, you're considered intestate. All right, so now we're going to move on and like, share, and subscribe because we're on legal matters right now. All right, now we're going to move on to the living will, which is also known as an advanced healthcare directive. It's a legal document that allows you to state your wishes regarding medical care in the event you become incapacitated, unable to make those decisions or communicate them for yourselves. It also outlines your preferences for medical care. And these types of preferences are usually advanced directive is one. Statements of your wishes made in advance of a potential need for medical intervention. Another one is end of life choices, where whether you want to be on life support or resuscitated. Some people do not. I know I've heard from others, a family member when they was on their last, that they never want to ever be resuscitated again because it was so harsh on them the first time. And some people do not like life support. So these are the things that are considered in a living will. The will is while you're living, you're doing what you should have done, and it's active while you're living, so that these things are implemented in your daily lives. For instance, the living will be initiated now instead of after your death, just to make it simple form for you. Medical decisions, you can appoint a healthcare agent like a health proxy in your living will who can also make healthcare decisions on your behalf if unable to do so. Choose wisely, because people will do what they want to do and not we've seen this in court, I've seen this in court, and not what you ask, especially if you cannot communicate or are incapacitated fully, where the person doesn't know. This is living will, is when you're able to tell people, so that if you come in that state of not being able to talk, discuss it, they'll already know. So be careful who you assign to be a health proxy or a healthcare agent. It's going to be someone you could trust and love. Most likely, I'm not saying all families are you can trust and love, but we would love that. So someone that's a great best friend, like a family, a sister, brother, or a family member of sort, husband and wife, if you're in good standings, because sometimes those things don't go right. And I've seen that in court where things change and now they don't want you around. It's in the news all the time. And so that's considered a living will. All right, a living trust is next. And a living trust is also drafting a will, but it's more simple and less expensive. Um, but creating a revocable and irrevocable trust is more private. Oh, what happened there? Is more private. It limits time and expense of probate. So maybe we want to look into that, a living trust. I'll explain that further. I'm just going through the basics today. So drafting a will is simpler and less when you do utilize this. And it's more private, and it limits time and expense of the court, probate court, or probate part. Some people call it part. We call it part, but other people call it court. It is one court. Surrogate court is one part. Sorry, surrogate court is one court, and we have parts in the court. So when people say, "Oh, I'm going to probate court," no, you're not. You're going to surrogate court. You're going to the part that is requested. We have accounting, we have administration, we have probate, we have everything there in that part of surrogate. I'll explain that in the next session, what parts are available in court, all the parts in surrogate court, okay? Because it's not separate. All right. Here's how they differ. A last will and testament takes effect upon death and must go through the probate process, okay? Um, where a living trust takes effect when a person is alive, like I said, and does not go through probate. See the difference? When you pass away, everybody's going to want to know. The court has to get involved to situate the situation so that it's distributed accordingly. And then that's when the people come up to oppose of the will, those who didn't get to be in the will, those that are in the will but they wanted more money, whatever the case is. All right. That's what probate part is for. What happens when you don't create a will or living will? Depending on which state you live in, the next step, the state, the court where that person resided will be in control of the deceased assets in order to distribute assets. If there are living relatives, hence the public administrator, yeah, that's the one that will help. If there are living relatives, they're supposed to find them publicly, because we're not going to know. The job is not for us to go calling people. That's where the public notices come in. And if the deceased has no living relatives, it will be liquidated to the state of, I'm just using New York right now because I'm using New York State. That's the only laws that I worked my whole life in, and that's the one I'm sticking with, because every law, every state has different laws. And sometimes when I go to other states and visit, I always try to visit their courts because I like to see what is going on there. And sometimes their procedures are so close, even in out of country. I've gone to courts to see the in third world courts, and everything is normally basically the same type of procedure, just a little bit different than the procedures in New York State. However, the laws are totally different. So just to keep that in mind. So in the state of New York, when you have your assets liquidated, it's called as cheat, which is done when there are no heirs or beneficiaries to claim it, and it reverts to the state. Yeah, that's after the public administrator and all means to try to find a living family member fails. Then any unpaid taxes and expenses will sit with New York State until there's probate on funds from, eventually, if someone comes, a cousin, um, not the first and second cousin, because they should have been around to know that this happened, but the far long family member that didn't even know their cousin or period, but they were related to them, things like that. For example, they'll be able to probate that they are a bloodline of the member that was deceased or is deceased. All right, so I'm going to go on. If you're married, what happens if you're married with a will? All right, let me just make sure, because I have wrote a few notes so I don't go all over the place. Yeah, if you're married with a will, the spouse is in control of the money of the deceased and all the assets to be distributed, the properties to the family if there was a will. For instance, children, mother, father, siblings, etc., 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 cousins, aunts, uncles, etc., etc., etc. So, and if separated or divorced without a will, hmm, did I do that right? With a will married, without a will married. Well, we know that even without a will married, you will definitely be able to, primary, the wife gets everything, especially if there's no will. So I didn't even put that in my notes, so excuse me, but I want to make sure that you know that what I just wrote is, if the will is there, that wife, that spouse, sorry, wife, male, female, husband, are in control of the assets. Now let's say that person is married and they didn't create a will, that spouse is still going to be in control of whatever happens, the death, the funeral, everything, and who and what goes to whom. And sometimes the children, the parents, the siblings will come to stop that person because there wasn't a will. That's where probate comes in. That's the probate part. We'll speak about that another time. Now, if you're separated, if this person or spouse was separated or divorced without a will, things happen, and you didn't have a will, but the person is separated. I'm going to start with separated, legally separated. And I say legally because it's important that you have on file legally. All right. So if legally separated, your spouse can still inherit your assets if you die without a will. If you die intestate, that separated wife, husband, spouse is still will still inherit your assets. So be very careful if you're not on good terms. This is why we do a living will now. Unless you remove them as a beneficiary, then they are still legally not liable, able to inherit your assets, whether they liked you or not, whether you broke up because they were with somebody else. Whatever the case scenario is, sometimes people, when they're separated, there's a reason for that, and you may not want this person to be the one with your assets, but things happen, you get sick, you forget, you don't have a will. This is why it's important, because this will also go to probate, because family members aren't going to have this person didn't love my son or my brother or my sister or my or my daughter, and how dare they want to take his estate or his assets, what's due to him. So remove them as a beneficiary. Once you get separated, my suggestion is not advice, I'm not an attorney, but my suggestion is get them off of your retirement documents, take them off of your health documents, take them off of everything they're a beneficiary on, especially bank cards, credit cards, bank accounts, anything you can think of that you have put this person on as a beneficiary. If you know that you're separated and you're not getting back, and even when you're separated and you don't know if you're getting back, just for safeness, because people come and go. We can, in other words, we anytime death can find you. So with that, you want to be sure that if it finds you before right now, how you feel about that person, I need to remove them as a beneficiary. If that's how you feel, do it. Okay. If legally separated with a will, I'm trying to go as slow as possible. Now the will is there. Your spouse can inherit your assets anyway, because you put it in your will. If you die before updating it, okay, remember this, they're already in the will, but you're separated now legally. You didn't expect that to happen between you two. So basically, you didn't know that that person and you were not going to be a forever. And it happens. It happens because sometimes people are not easy to be live with, and sometimes people don't want to work on relationships. So things like this can happen. If you die before updating your existing one or a new will, this person can actually inherit. The legally separated spouse can actually inherit anyway, and can be removed actually as a beneficiary, but only if you do this in the will, after the separation, because no one plans, let me see, I'm separated, but I'm going to write the will now. You don't think of things like that. You think of, okay, before separation, you wrote this will, and now you're separated. So it can be removed as a beneficiary. You can update your will, and there's a way to do that. Update the will to what you want it to be now. And without the will, take everyone off that you do not want their spouse or anyone, if you're legally separated, off as a beneficiary in everything that you have. Take it off. All right. That's the only way to protect yourself. Now, divorced. If you're divorced and your husband or spouse died, your ex-spouse died, I know there's a lot of greedy people out there, so they're still going to see if they're going to get anything. So if the will was made and that person put you in there, good for you. But if not, there have been people coming to the courts to probate, and they haven't been with this person. Maybe it could have happened 6 months to 10 years. They're still coming to get something. I mean, This is why I see people don't get married, but I encourage, if you love someone and you want to, it's not bad. It's um, how your reaction to a situation is, and it's not everyone else's. And anyway, we're on a different subject now, so I won't go there. I'll probably do something like that on Know Your Truth Real Talk. So divorce, if not settled in the divorce decree, they are not entitled to any of the deceased assets, but it may not stop them from trying. Yeah, just like I said. Again, let me report. If there's a divorced spouse that comes later on, it could be 6 months to 10, 20 years. Um, if there is not if it was not settled in the divorce decree, they are not entitled to any of deceased assets, but it may not stop them from trying. Yeah, I've seen that as well. It's horrible. I'll go on. If not married at all, so you never married this person legally, but you may be common law. A lot of people don't look at that as legal anyway because it's not on paper, but in some states it is. So if, and then I'll get on that one, common law marriage. Yeah, I'll have to look that up because some law states you are common law married common via common law. But if not married at all, let's say you have a spouse you live together for years or maybe not, and they passed with a will or without a will. So let me go through. If not married, with will or without a will, varies. So I'm going to start out with a will. If not married, with a will, and if named in the will, may include partner depending on relationship. It may include the partner depending on the relationship between the two prior to their death. So that's a scenario that it depends on. It will, if you're in the will, you're in the will, but it may include. It doesn't have to because you're not married to this person, but it depends on the situation, the relationship between the two prior to death. If someone has put it in their will, if it's not in there, don't take it bad. They may not have felt about you like that. And if it is in the will, then they did. If you don't like the amount, that's what the court is there. We can't dispute that, but there will be people disputing stuff. So let's move on about if not married without a will. We started talking about if married with a will, and now we're going to talk about if not married. I'm sorry, if not married with a will, and now we're talking about if not married without a will. I'm sorry, I'm trying to not confuse you guys because legal information is really not easy to explain unless you're an attorney, which they're trained to do all day long. I'm trained in procedures, which they need me for in the courts, but we all need each other, right? All right, so without a will, if you're married, if you were not married and you're a partner, not a spouse, you're just a partner in the relationship, you've been with them for years or not. Without a will, the likelihood of partner attaining property assets are slim. They're very slim. It can happen, but it's very slim if family, the bloodline, are involved. And this may require probate if the partner feels he or she should be a part of that deceased, should inherit a part of that deceased property, their property and assets. And a lot of people feel that if I've been there for that person, I should be able to. Hence the reason why marriage is important, but for some it's not, and I understand that. And so then you deal with these type of things. You got to implement something um, when you're going to have a long partnership and make sure it works for you, because the court will definitely give the decision out on who gets what if this isn't done with a will. So be very careful. Now, who can create a living will? You are able to create it at any age, young or old. Some may need an attorney if there is a large estate, assets, and properties involved. You will definitely need an attorney. I suggest that. I know a few people that had to get attorneys. It went smooth, and some people it did not in the courts. And those are when you have like, I would say if you have over 50,000, because some families are so bad that even 50,000 is a lot to them. And I understand that. So I think if anything over 50,000, actually I would start with more, but you know, people are real petty and I've seen it in the court. you would need to hire an attorney. 50,000 is not, to me, enough to hire an attorney, because you have to pay them per hour, and the money you're going to get if there's 20 family members fighting for it, it's not worth it. But some people may have to do it, just for 50,000. I've seen it. So just be very careful when you're doing your living will, and when you're thinking outside the box of who should and should not receive whatever you give, gifts or whatever it is in your will, living will or living trust. It's really important that you trust and love that person. Things do change, so always have a codicil or an amendment attached to it. I would do that. I just thought of that now, just in case if things were to change. I would put that. I would implement that, and but they wouldn't know if it changed. But like, let's say it's a separation, but you're not separated right now. I would put a codicil to that will stating that, and that codicil means to add like an amendment to the will, if in case we separate, divorce, blah blah blah, what do you want that person to get? And so, with that being said, I'm going to end it here. I just wanted to say something, because when I studied in college, wills, trusts, and estate law, they called it dead law, because it was so much. That's all you hear: when this person died, when that person died, blah, 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 blah. And attorneys have no problem talking about it. But it's just the feeling and the impact of it. It's like, wow, dag, even through death. But either way, so we call this dead law. And on session 2 of this, I'm going to bring it on next month in April, the ending, because I do monthly on legal matters. On legal matters, the next show on session 2 of wills, the basic steps for the layperson. I will discuss the court procedures of how to file documents in the courts, where it should be filed, the specific documents required if you are filing for yourself or for someone else. I'll also do the parts that I just said to help you recognize the parts of surrogate courts, the probate, administrative, um, administration. I mean, that's where you put the administrative of letters, you file them there. I'll explain what those are next one. And accounting, that's where they distribute the funds and monies that goes to those that have passed, and those are the estates and properties and stuff like that. So I will try to help you recognize with the parts of those parts of the court, um, and any necessary details uh, to think about if you were or were not named in a will, or if there isn't a will. And I also will discuss further on a living trust for sure. Now, I just want you to know, I'm not sure if surrogate, I remember filing, electronic filing system, but I don't think it's the same. They may have upgraded by now, but the New York State court system has electronic filing for everything. It's paperless judges now, because it's quicker to put it up in a computer and store it and download it and print it later, or file that way. So if, God forbid, someone's sick or in their deathbed or whatever, if they don't have an attorney, they can actually file online. You could go to New York State courts.gov, nycourts.gov. They stopped New York State courts. So it's NY, New York courts.gov, and you can look up the electronic filing system there and get familiar with it, because at some point or time in your life, everyone goes to court, even if it's for this, what we just discussed. And if you don't, good for you. You don't need to. You did everything right. And so we will just discuss all these things further, and I'll try to see what I've left out, because when it comes to legal matters, there's always, sometimes it's not just a part 1 or a session 1. Sometimes it's several sessions. So next month we will be on this session 2 of this video. If you have questions, please email me. I have my email here. You don't have to message me here on chat at all, because no one else needs to know your business. You can give me a shout out on the email. If you have my number, you could call me or leave me a message. Message me on my Facebook, Instagram. I'm on all social media, Judge Desire for Knowledge. Thank you. Share, subscribe, and like. Please like. It's free. I'm doing this out of my heart because I like people a lot and I don't mind helping others. So, with that being said, put in a like, Like, for free for people that don't mind helping others is very genuine. So, as I like you all here, I love my fans and my subscribers. I don't want to say fans. I don't like to be a fan. No, I don't want fans. I love subscribers. I'm not trying to be famous for this. I'm trying to do my part here, give the message, the truth to you here, with the truth and nothing but the truth on legal matters with me. Judge Desire for Knowledge is now adjourned. And I will see you all next Saturday for Know Your Truth Real Talk on YouTube at 3 p.m. precisely. Whether it's whether it's live or taped. I'll see you there, and I hope you're all safe. Have a great Saturday. Have a great weekend. Love you all. Bye, JD4K family. Until the next time, ciao.